All right. Jimmy says the law in Texas is not that ambiguous. Now, let me ask you, here's New York. So before we go and say, oh, things are crazy down south. In New York, it says, as you can see on your screen, parent, guardian, or other person with care and supervision of a person under 21 can use non-deadly physical force when and to the extent he reasonably believes necessary to maintain discipline or promote welfare of a person performed upon. What does that mean?
I'll tell you why. And as I look at it, this is a little bit more broad, but okay, think about it. Reasonably believes necessary to maintain discipline. What's the kid doing? The point is if the child is not behaving or doing something that could cause danger to him, the parent can use force to stop that. That's what that means. So the question becomes, what was this 4-year-old doing?
Okay, but wait.
Such that,
okay, here's my thing.
That
Assume
kind of
the
force
kid's not getting sick. Let's take us at the table. The 4-year-old kid, I say, go to bed, it's bedtime. The kid says, no, I ain't going, right? One of us, Doug, decides he's going to rationalize with the kid and tell him where to go. You smack one on the bum. Me, I go to the back of the head or the face. Mayo winds up, and he goes for the extension cord. Under that state law, right, I believe if the parent believes it's what's necessary to enforce discipline, why can't I read into that and say, do whatever you do?
That's what Mark was saying. It's the reasonable person. It's not judged by, there may be a subjective component like in self-defense, but it is what a reasonable person would do. A reasonable person would not take a baseball bat or a branch and beat a 4-year-old silly because a 4-year-old is refusing to go to bed. But if an East Texas
jury says, hey, that's what we do down here, then it's okay.
But you know, Rich, if you're looking for more specificity in the statute, if that statute actually said you can't use a bat, you can't use an extension cord, you can use, then
how about a prop?
But listen, somebody would be able to say, well, I used a frying pan, and that wasn't in the statute, therefore, so that when you're looking at that statute, it's not clear. What you're searching for is the reason why. You want to go back to what Mark was saying, what a reasonable person.
All right, let me for time. The National Football League Players Association, they have filed an appeal, Ray Rice. Ray Rice, as we know, got originally 2 games. Hue and cry breaks out here. We see the video from the elevator, and shockingly to some people, that's how she ended up unconscious. Anyway, he's now suspended indefinitely and obviously cut by the team. Well, he is appealing that, and this is what the NFLPA had to say. Play the clip.
We believe that Ray Rice has been punished twice for the same offense and that the NFL had all the evidence available to them during their decision to punish Ray for 2 games initially.
Can you make the argument of double jeopardy? Can't the commissioner say I have discretion to enforce, punishment as I see fit, even if I didn't get it right the first time?
If you're in a court of law, absolutely, but the question really comes down to what their collective bargaining agreement says, and if it says that you cannot be punished twice for the same conduct, then there's a great case there. Because to me, again, as we discussed this, I think, a week ago, it's clear that his now wife suffered some injury, and it's presumed that that would have come from a punch before you actually see the second video. The second video actually is probably more favorable to Ray Rice because it's 1 punch. When you see what happened, the aftermath, it could have been 5 or 6 punches. So it's not as if they were somehow mystified as to how she came to that state. And it's all basically just politics. Again, they're trying to basically save the financial well-being of the NFL.
And there could be a little precedent here, Mark, because what they're also saying is, time out. You, Roger Goodell, by the way, if we move forward with this, you're the one who levied the punishment or said the suspension. You can't also be judge and jury because he would be the person that would hear the appeal under this, right?
He's already said that it's going to go to a neutral third-party arbitrator, and what the case is going to turn on is the latter part of the NFLPA's rep's statement. Was that evidence truly available to the NFL, or was it in the NFL's actual possession? You have an AP report that says law enforcement mailed it to them contemporaneously months and months ago.
I'm sorry to interrupt. Yeah. Do you think, as we know, the former FBI director is doing a independent investigation? Some people question his true autonomy there.
We had that with Penn State, too.
Right. Do you believe that, in this case, the NFLPA would trust that report, or would they have their own investigations? Because that's really what could end up getting Roger Goodell fired.
Well, I wouldn't trust it at all, because in my opinion, the prime impetus for this supplemental discipline is CYA. It's a cover-up. I mean, this is cover-up gate. They had to have known, as Mayo said, or they could have at least extrapolated what happened. And if this tape was in fact in the NFL's possession, it's going to be very, very bad for the league. Do I think it's going to stop people from watching football? Absolutely not.
Now, to you two guys, we've seen a whole spate of cases. Greg Hardy down in North Carolina. You have a guy in the 49ers also facing a case. I understand there's a new case now that's coming out from the Browns. And this tortured response. There's Greg Hardy from the Panthers. Originally, in the beginning of the week, they said he was still going to play because they had to let the courts play it out. Vikings did the same thing. After suspending Adrian Peterson for the first game of the season, they said they were going to let him play, and then they saw the backlash with sponsors, and all of a sudden they didn't. Can we put to rest that you can still pay somebody if there's a contract, but that doesn't mean you got to let them on the field? There's discretion by whatever organization there is to say, you know what, you don't have to represent me as a firm or an organization.
I think that it depends on the agreement between the parties, but absolutely, you can pay, but that doesn't mean you need to let them play. The thing that concerns me is that there is no stance. The stance, it's whichever way public sentiment blows. So that's the problem. So Peterson can play until he can't play because there's a public outcry. Make the right decision, or make the decision you're going to stand by first. And that's just not what you're getting here. But I'm sure that contractually, if you're going to pay the guy, it doesn't mean you need to let him play. It depends on the agreement between them.
Final pearl of wisdom here in 20 seconds.
Well, I don't understand why what these guys do for a living is so tied up in how they make a living and in what they're doing in the courts. If they get convicted, if a prosecutor wants to put them in jail, go ahead, do it. But why does that really have to do with what they do for a living?
Especially when Michael Vick gets convicted of a federal felony, does his time, and he's back on the field. There are so many different messages that are being bandied back and forth.
And that's a perfect note to end on here, because, whoa. Thank you all, guys, very much here. And I definitely next week want to get into this one about when you have to or not produce your ID here, because that in itself is interesting. All the time we have for tonight here. I'll see you tomorrow at 6 p.m. as always. These guys will see you next Wednesday.